Someone make it make sense.
Probably a couple.
Hello, everybody. Welcome on in. Come on in. Take a seat here. We're going to hit up some of these Kohberger docs, and then this live stream should redirect you guys into our next live stream, which will be covering today's testimony from Karen Reed, along with the latest court filings and all of that good stuff. So yeah, so as we can see here, here's the docket. So nothing's been new as since since Thursday or Friday of last week. They say new, but there's nothing new after these. So of course, some of these are sealed. So we are going to be covering what we can here. Welcome, Meg. Happy to see you as always, my friend. So yeah, hopefully you guys are not having crappy weather like we have been having here. Huge temperature swings and storms and torrential downpours. I think we're on a flash flood warning. Oh my God, no weather, no location provided. Flash flood warning right now as of right meow. So, but okay. So first up, here we go. We do have here the order on the defendant's family members in the courtroom. Zoom in a smidgens. There we go. Okay. Coolio. All right. So in its order on motion in limine regarding the family members in the courtroom, the court ordered the state to submit for an ex parte in-camera review a list of defendant's immediate family members it intends to call at trial. The purpose for calling them, whether they can be called early in the case, and why exclusion from the courtroom prior to providing testimony is necessary. The state timely complied with this directive. Having considered the state's response, the court, exercising its discretion, footnote 1, permitting exceptions to an exclusion order under the rules is discretionary. Okay, exclusion order as pertains to witnesses, right? Finds good cause to excuse defendant's immediate family, i.e. parents and siblings, from the anticipated exclusion order that will be entered under the rules prior to trial. United States Supreme Court has recognized that the right to a public trial afforded by the Sixth Amendment entitles a criminal defendant at the very least to have his friends, relatives, and counsel present, no matter with what offense he may be charged. Courts recognize that having a defendant's family members present at trial advances the values served by the right to a public trial, ensuring fair proceedings, reminding the prosecutor and judge of their grave responsibilities, discouraging perjury, and encouraging witnesses to come forward. Like other constitutional rights, a defendant's right to a public trial is not absolute. Okay, a lot of this we know. Here, the court must balance the defendant's right to have his family members present at the trial against the state's interests in excluding testifying witnesses from trial under the rules. The purpose of exclusion of witnesses under the rules is to reduce the possibility of a witness shaping his testimony to conform with or to rebut prior testimony of others. Right. Whoa, it's 91 degrees in Rapid City? What? Is that for real? That's crazy. What did it say it was here? 67 here, but I think the real feels probably lower than that. Wow, that's crazy. Yeah, I'm with you on this one though. I like it hot and dry as well. I would love to be there. Okay, so under the circumstances here, the court does not find that excluding the testifying members of the Kohberger family will serve this purpose. Namely, the scope of the family members' proposed testimony is very narrow and is not necessarily tied to the testimony of other witnesses. Further, the family members were previously interviewed regarding the matters on which they will be questioned at trial. These prior recordings serve to protect against any attempt by the family members to mold their testimony based on how others testify before them. In addition, the trial publicity is such that defendants' family members are likely aware of what testimony and evidence will be in the state's case in chief. Thus, exclusion pending their testimony will not necessarily prevent them from conforming their testimony. That's interesting because I would not rely on the trial publicity, as in mainstream media, to I would not rely on that to be like, here's what's going to be in the case in chief, state's case in chief. Anyway, thus exclusion pending their testimony will not necessarily prevent them from conforming their testimony. Finally, the state has indicated it would prefer that the family members remain in the courtroom and be called when the state sees fit, rather than calling them as out of order witnesses. So that's fair. saying that they don't want to have to say, well, we'll call them first, and get their testimony out of the way. We'd rather be able to call them when we see fit, if we call them, and therefore, again, that warrants allowing them to be present. Welcome on in, Leslie and Billy. Happy to see you as well, my friend. In sum, given that the defendant's right to a public trial in general, the importance of the presence of his family members to both the defendant and to the family members, and exclusion of his testifying family members under the rules will not advance the purposes of the trial. The court will allow them to remain in the courtroom throughout the trial. Excellent. Fair. Good decision here by Judge. I think he made the right call. Happy to see that he made the right call on this decision. And also, thank you for mentioning this, Leslie and Billy. Let's just take a moment to say shout out to all our beautiful mothers out there, whether you have human children or paw babies, paw nerds as it were. Happy Mother's Day to everyone, one and all. So I'm glad you mentioned that, Leslie. Okay, so next up. Moving right along. So now we have, all right. So what this is pertaining to, in case anyone isn't familiar here, this has to do with the penalty phase, right? So whenever you've got mental health at issue, right? Whenever like for example, if the defendant, like in this case, right, has been examined and is bringing that in. And the same would apply for the guilt phase, but that's not applicable here. But either way, if it's in the guilt phase, here it's in the penalty phase, the state has the right to also have their own expert examine the defendant. That's just how it goes. So the defense was, I'm sure, expecting that to happen, but we also have here a request or a motion for an extension of the deadline. You texted your brother, Happy Mothers? Interesting. Brother can be a mother too. Yeah, let me know, guys, in the chat. Did you guys watch the Dateline special? Did you guys watch it? And if so, what were your thoughts? I didn't watch the whole thing. I just went straight for the clips with the Elantra and the cell phone so I could clip those out and have those without it being, without the logos and whatnot. But the parts that I saw in passing while I was finding those were infuriating. Meg says, I told my husband I wanted alone time for Mother's Day, so he shut the door and left me upstairs with the kids while he played games. Well, there you go. Shout out to Meg's husband, who's also a pilot. And glad you mentioned that, Meg. We are going to take a look at the non-dissemination order as well to refresh all of our memories. We are going to do that. We are going to do that as well. That's going to be up next after this. Okay. And actually, I was planning on doing it anyway, because on our last live stream, we were talking about it. We were like trying to remember the terms of that non-dissemination order. And so even before the Dateline thing came out, I was like, we should take a look. So anyway, take a look. It's in a book, a non-dissemination order. Anyway, okay. So here we have the order on the state's motion for the examination and extension of the deadline. All right. So let me zoom in some more here. Excellent. Before the court is the state's motion to conduct an examination of defendant pursuant to the rules and to extend the penalty phase rebuttal disclosure deadline to accommodate opinions arising from that examination. Defendant does not dispute that his penalty phase expert disclosures opining his mental conditions, literally what I was just saying, right, triggers the state's right under the statute to conduct its own mental health examination. Yep. What is in dispute, however, is the scope of the examination, whether defense counsel may be present, whether the state has shown good cause to extend the rebuttal disclosure deadline. Oral argument, footnote 1. Because the motion was likely to and did generate discussion about issues concerning defendant's mental health, including matters not admissible at trial, the court sealed the hearing pursuant to the rules to protect against the disclosure of highly intimate facts which would be highly objectionable to a reasonable person if disseminated, and to preserve the defendant's right to a fair trial. Sealing the hearing was the least restrictive way to protect the privacy interests at issue. Neither party objected to the sealing hearing, and I think that's fair. That is powerful course, as they say. So oral argument was held by video conference on May 5th, after which the court ruled from the bench. This order memorializes that ruling. So while we didn't get to see the hearing, we are now getting this memorialized ruling. So excellent. He ruled from the bench, though, as he said. So standards. Constitutional questions are questions of law. Whether good cause has been shown for an extension of time is a discretionary issue. On discretionary matters, the trial court must, 1, correctly perceived the issue as one of discretion. 2, this is the same exact thing he cites on all of these, so I'm not going to read all that. All right, procedural background. On January 23rd, 2025, defendant timely disclosed guilt phase expert opinions by 2 mental health professionals who examined defendant and subsequently diagnosed him with various mental and behavioral conditions, including ASD, OCD, and ADHD. Following those disclosures, the state provisionally retained a psychologist to conduct an examination of the defendant pursuant to the rules and provide a report for rebuttal purposes. Footnote 2. The state also moved in limine to exclude the proposed penalty phase testimony by these 2 experts on grounds that their opinions did not constitute a mental element defense and therefore did not fall within the scope of the rules. The court ultimately held that testimony by 2 experts during the penalty phase would not be permitted, with limited exception, unless the defendant testifies at trial. Right. And we read that order on the motion to eliminate. Right. Okay. So I still think he got it. You guys remember when I lost it because he was saying penalty, and I was like, no, he means the guilt phase. I think he did it again here. Because clearly they're going to be testifying for the penalty phase. I think he did that again here. And the mental element defense, that is, I think he did this again here. Well, we'll keep reading and see if that gets any clearer, but it was very obvious in this filing here, this order on the state's motion to eliminate neuropsychological and psychiatric evidence. It was very clear that he meant to say guilt phase when he said penalty phase. And I wonder if he did that again here. Okay. So that was footnote 2. Welcome on in, Kelly. Happy to see you. On March 31st, 2025, defendant timely disclosed penalty phase expert opinions. See, again, this is making a distinction, right? Penalty phase expert opinions by 5 mental health professionals. That again would make it seem like he's just getting this. And here it says guilt phase. Okay. There we go. That's my answer. Let me go through this again. So this is guilt phase expert opinions by 2 mental health professionals, right? And then we have this footnote 2, where Judge Hippler makes the same mistake as he did before and says penalty phase when he means guilt phase. They're limited on what they can do during the guilt phase unless he testifies. That does not apply to the penalty phase, so that's a mistake in the footnote. Okay, now we're getting to the penalty phase. Okay, so 5 mental health professionals, including the 2 previously disclosed, regarding his various mental and behavioral health conditions. The deadlines for the state's penalty phase expert disclosures was set for April 28th. So we're past that. On April 2nd, 2025, the state initiated communications with defense counsel about conducting an examination of the defendant pursuant to the rules. Defense counsel responded that same day requesting the name of the experts, the nature of the testing, and whether there was any objection to defense counsel being present for the exam. The following day, the state provided the information requested, including the proposed testing. Among the tests listed was an assessment of personality structure, and that's in quotes. The state also objected to the defense counsel being present. So those are the things. So again, scope and defense counsel being present, those are the things that were at issue here. In response, defense counsel did not object to the evaluation, but did object to any testing outside the scope of what the defendant's experts had conducted, specifically personality testing. You guys can imagine why. Welcome, James. She also asked the state to reconsider its position as to having counsel present during the examination. Interesting that he says she and not counsel also asked. Anyway. On April 7th, the state responded indicating it would not remove there's a footnote here, footnote 3. Both parties agree that the defendant's disclosure of his psychological experts to testify in mitigation triggered a waiver of any privilege by the defendant and a mandatory right of the state to have its experts conduct an examination of the defendant. Right, and that was already addressed, and I also mentioned that as well. All right, so then on April 7th, the state responded indicating it would not remove personality testing from the proposed, examination. It would not agree to counsel being present. So they're saying we're not going to compromise, or we're not going to give you any of those. So counsel being present during the examination, except through a video feed or otherwise by having counsel shielded from defendant's view. Okay, that's fairer. On April 11th, 2025, the state's mental health expert informed counsel he was not able to continue on the case. Okay. I want to know why. Was there a conflict? Tell me why. Approximately 1 week later, the state retained a replacement doctor and then redacted until the state formally disclosed the expert and informed the defendant of such the person. The state indicated it still needed to discuss with specifics of the examination with their new doctor, including his position on having counsel present. On April 22nd, 2025, the state alerted defense counsel via email that their new doctor believed personality testing was warranted and objected to the counsel's presence. The state also sought a stipulation to extend the rebuttal disclosure deadline for purposes of disclosing the doctor's opinion. Defense counsel responded that same day, objecting to the deadline extension to personality testing and to her exclusion from the room. Again, saying her. Sounds like he's referencing one particular attorney. Could be Anne, could be Miss Mesa, we don't know. But it's still interesting that he's singling somebody out. On March 25th, 2025, the state filed the current motion. Analysis. In its motion, the state seeks an order from the court, 1, extending the deadline for its penalty phase rebuttal disclosures for 21 days following the completion of the state's expert examination, 2, allowing for the state's expert to administer standardized personality testing on the defendant, and 3, excluding defense counsel's presence at the examination. So 3 things: extending the deadline, allowing them to administer the personality testing, and excluding, and number 3 is excluding defense counsel. Defendant responds that 1, there's no good cause for the extension. It would be highly prejudicial given the posture of this case. 2, personality testing is beyond the scope of rebuttal and would violate his Fifth Amendment rights against self-incrimination. And 3, counsel's presence during the examination is required by the Sixth Amendment. I'm surprised they're kind of fighting back on the first one, because again, sometimes if you can agree to one thing, you can do better on the other issues, right? And again, I think there is good cause for extension if they have somebody that's unavailable, right? I would concede that, but I would stay firmly on points 2 and 3 if I were the defense. But that's just me. So James is requesting the waterfall. James, that video is available and you can watch it anytime. It's not just when I play it on a live stream. It's just a standalone video, and you can watch it anytime you please. Welcome on in, Mary. Happy to see you again, our Scroll Crew resident archaeologist. Okay, so as indicated at the hearing on the motion, the court finds good cause for a short extension of the deadline. Yeah, as I said. As for the examination, personality testing will not be allowed. Oh, good. Nor will counsel's presence in the examination room be allowed. Okay, so I'm happy with this decision that personality testing will not be allowed. I think that was the right call. So far, Judge Hippler has, I think he made the right call, allowing the family to be present. Now we're on for this one here. I think extending the deadline by a short period of time is fair. And I also think that not allowing the personality testing is also fair. Now, the question will be, in my mind, will he allow them to be present via Zoom or whatever, virtually, right? Because that was one of the other things that was offered, for the counsel to be present some other, but not in the room, right? Let's read on. A limited extension of the rebuttal disclosures deadline is warranted, right? And I'm not too worried about this. I think that is par for the course. Goes without saying. Okay, we've got a couple footnotes though. See if there's anything good here. Granting this extension, though limited by the court in both scope and time, is consistent with the substantive and mandatory, i.e. non-discretionary right of the state to conduct such an examination. Okay, whatever. Given that time was of the essence, the state should have considered, there's a lot of typos in here, should consider filing a motion to extend the deadline at the latest by April 3rd after it learned defendant would be objecting to personality testing and exclusion of counsel from the examination. While the court appreciates the counsel attempted to reach resolution with the court's involvement, without the court's involvement, this is a significant matter that called for prompt resolution once it appeared the parties were at odds. So basically, he's kind of calling out the state here. Again, I have to say, Judge Hippler, happy with this. What he's saying, I thought literally the same thing when you're reading it. I was like, seems like the state could have filed sooner, right? To extend the deadline, but there was a delay. And he's saying, while he appreciates that they attempted to reach a resolution without the court's involvement, they should have went ahead and addressed this for prompt resolution earlier. So remember, we've seen him handle this a little, similarly with things from the defense. it's different circumstances, right? But like basically, look, you get a warning one time, but the next time you do it without filing for the, in the defense's case, it was an extension of the page limit, or a motion to exceed the page limit, I believe is what it was. Similar type of thing here, where it's like, look, here's your warning, but next time you need to file it, in a timely fashion, right? And then footnote 6, in its oral ruling, the court indicated the extension would be 21 days from the date of the hearing, which falls on Memorial Day. Due to the holiday, left out the word to, the court will allow the state an extra day. Given the deadline follows a holiday weekend, the court expects defendant will be flexible if a day or two extra is needed. Okay. All right. So those were the footnotes. So, okay. While the state should have filed its motion to extend the deadline weeks sooner, the court is sympathetic to the fact that the state's mental health expert, who has been provisionally retained shortly after the defendant's guilt phase expert disclosures, decided to withdraw from the case just 2 weeks prior to the rebuttal disclosure deadline, leaving the state to scramble to retain another expert. Based on the state's representations during the hearing, the expert's withdrawal was unforeseen by and beyond the control of the prosecution. Until redacted was retained, the state did not know his position on the two issues holding up the examination, i.e. personality testing and presence of counsel. Once the state learned of his position, sorry, I inhaled my spit. Take a sip of water. That never helps, but we always do that, don't we? If we inhale our spit or something, take a sip of water, I don't think it helps, but what else are you going to do, right? All right. Once the state learned of his position and confirmed defendant's objections, it moved accordingly. Considering these circumstances, the court finds the delay to be more attributable to the prior expert's unexpected withdrawal than lack of diligence by the state. However, a state's request to extend their rebuttal disclosure deadline to 21 days after the examination runs the risk of prejudicing the defendant. Given the posture of this case, the volume of discovery, and the upcoming trial date, the court will only allow an extension to May 27th, 2025, and we already read that footnote. So the defendant has ample time to consider and potentially respond to the state's disclosure. Defendant shall be made available to the state's expert for examination within the next 7 to 10 days, thus leaving the doctor approximately 2 weeks to complete his report. Okay. Personality testing will not be allowed. Right. The state seeks to allow its expert to conduct personality tests on the defendant during the examination to confirm, rebut, or otherwise contextualize the neuropsychological conditions diagnosed by the defendant's experts, particularly ASD. The state argues there's no basis to limit. By the way, I'm pausing myself as I'm reading this to say something. Mary was headed to Colorado to take a look at some owls, and Leslie, if you're still here in the chat, happens to be a huge owl fan. I think we're all owl fans, really, but I know that Leslie's thumbnail picture, I think actually, if it's still the same as it was last time I saw it, is an owl. So anyway, just thought I would let y'all know that there's an owl overlap in terms of people's interests. But again, I think we're all interested in owls, right? I mean, we even have the custom emoji. Anywho, sorry. Okay, let me keep reading. The neuropsychological conditions diagnosed by the defendant's experts, particularly ASD. The state argues there is no basis to limit its doctor's professional judgment as to the appropriate areas of examination. And further, defendant has opened the door by offering testimony about his lack of personality disorder. Footnote 7. One of the defendant's the forensic psychiatrist, Dr. Eileen Ryan, concluded in her expert report that the defendant does not have a childhood history of behavior that is consistent with conduct disorder or antisocial personality disorder in adulthood, nor does he meet the criteria for antisocial personality disorder. Okay. I think that's new information to us because that was in part, I think that was in part of the disclosure that was, sealed or whatever, which happens, right? In these orders from Judge Hippler, sometimes we get new information. Where was that? Okay. Right. So the state's arguing the defendant opened the door. That's what this is. The state contends it will only seek to utilize the results of the examination as rebuttal evidence in the penalty phase and will disclose all of the results of the examination to the defendant. The defendant objects, arguing personality tests exceed the scope of proper rebuttal. He points out his own experts did not perform personality testing or diagnose him with a personality disorder. Rather, his proffered evidence concerns diagnoses of ASD, OCD, ADHD, and his history of eating disorders and substance abuse. Interesting. That's new information as far as on the court record or in the court record here as well. He also argues nature of personality testing violates his Fifth Amendment right against self-incrimination. As both parties appear to agree, the scope of the state's examination of the defendant is confined to the purposes of rebuttal. This is born out of the language of the code, which provides for a limited Fifth Amendment waiver for the mental condition placed at issue, stating, no court shall, over the objection of any party, receive the evidence of any expert witness on any issue of mental condition or permit such evidence to be placed before a jury, unless such evidence is fully subject to the adversarial process in at least the following particulars. Raising an issue of mental condition in a criminal proceeding shall constitute a waiver of any privilege that might otherwise be interposed to bar the production of evidence on the subject, and that's in italics. And upon request, the court shall order that the state's experts shall have access to the defendant in such cases for the purpose of having its own experts conduct an examination in preparation for any legal proceeding at which the defendant's mental condition may be an issue. The subject to which the waiver applies is an issue of mental condition. In other words, the statute does not provide for a waiver of a defendant's entire mental condition. It only waives privilege attaching to the mental condition he chooses to place before the jury, so as to allow the state to controvert his proof on an issue that he has interjected in the case. Well said. And I think I agree. In other words, you don't just get access to his entire brain. It's not like, have at ye, state. It's not like that, right? It's only whatever they raise issue on is what you can, examine. This is consistent with well-settled waiver principles under the Fifth Amendment. Okay. Indeed, it is recognized among courts that waiver under the provisions similar to the code is limited to the issue raised by the defense. And we don't need to read all of this. This is all well-settled law here, case law. Here, the parties do not dispute that the scope of the state's examination is limited to rebut the mental conditions the defendant has placed at issue. They agree that the state cannot explore new diagnoses or mental health conditions other than those placed at issue. What they dispute is the manner in which the examination may proceed, specifically whether personality testing shall be allowed. According to the defendant, personality testing proposed should not be allowed because it is not aimed at revealing proper rebuttal evidence. So then there's some case law here. There must be a nexus. Defendant notes that his proffered evidence is limited to these diagnoses, as mentioned before. Because he's not been diagnosed or even tested for a personality disorder, he argues such testing is beyond the scope of rebuttal. So such bad news that you didn't get to see any owls. That's such a shame. What's your next journey that you're going to be taking? Let us know. So they've got some different cases that they're relying upon here. The state responds that it is not proposing the personality test simply as a fishing expedition. Rather, he believes, I guess he being the state, weird, that the test will aid in rebuttal for several reasons, as he, being the state, explains. Or I guess it's their expert, right, who they can't name. My professional opinion, including broader testing of personality and psychopathology, is important for several reasons. First, these tests contain the most sensitive symptom validity measures to help determine if the examinee is reporting information in a consistent and reliable manner. Oh, are we going to be getting into, oh, fuck. Oh my God, why am I blanking on the name? All the tests that they used in Deputy Heard. The MMPI, like MMPI type of stuff. Without significant over-reporting. Yep, this sounds like MMPI territory. Interesting. So over-reporting, so exaggeration, or under-reporting, defensiveness. In her evaluation of the defendant, it does not appear that these doctors administered any tests that formally evaluate symptom validity to this level. These validity measures help ensure that the results of other self-report measures do not contain validity scales that are valid. Second, not only is it important to rule in diagnoses such as those that have already been diagnosed, but also to rule out diagnoses that could account for the same symptom presentation. The diagnostic criterion for many disorders includes that symptoms are not attributed to or are not better accounted for by another condition. Therefore, ruling out those conditions is important. Third, with autism specifically, there are certain personality characteristics that are common and supportive of that diagnosis. Obtaining information about those characteristics helps ensure a proper diagnosis. The battery of testing that I propose would be significantly less than the testing battery already completed by Dr. Orr. Well, that doesn't make a difference, so if it's outside the scope. Anyway, the battery would serve to supplement the battery that Dr. Orr completed and provide some additional valuable information. In my professional judgment, I would not administer the hair PCLR that is discussed in the report of the defense expert. I bet he wants to do MMPI. We'll see if that's mentioned. The state also notes that to the extent that, oh my God, look, they spelled it te. Ugh. To the extent the testing strays from its rebuttal purpose in any respect, there is no prejudice to the defendant because he will have a chance to object prior to admission of the evidence at trial. To this end, the state cites to various cases where courts have declined to impose strict limits on the scope of court-ordered psychological exams, observing that even if the examination exceeds the scope of reasonable rebuttal, it will not be admitted at trial. So what the state is trying to say here is that, look, we can always examine him further, with a larger scope, but that doesn't mean it's going to get admitted. Sorry, no. That sounds like being weaselly to me to try, because once you have that information, you're going to try to get it in. Oh, interesting. Yeah, keep us posted. So the court's concern with allowing the state's expert to conduct personality testing is twofold. First, the court is not convinced from the expert's explanation that the testing is within the scope of rebuttal. Yeah, I'm not convinced. The first purpose identified, i.e. to ensure defendant's self-reported symptoms are valid, might carry great importance if Dr. Orr's diagnoses were made largely based on the defendant's self-reporting, but they were not. I will just say, I just want to say something. I try to be as objective as possible, right? I will just say this. In my opinion, from my perspective, if this had been Judge Bev, all the states, this would have been granted for the state. It would have been, go ahead, do your personality testing, right? I just wanted to make that distinction. I think if this was Judge Bev, like so far from everything I've read on this live stream, Judge Hippler's orders have been extremely fair. And by fair, they're fair, but by being fair, I guess by definition, you can't say it's in favor of one side or the other because it's just fair, right? Allowing the family in the courtroom again, denying the personality testing. I think extending the deadline for the state was fair, and he's just making a very thorough record here. So we'll see what else he says. But again, I just think that I think this is all very fair so far. I haven't been pissed off once, so that's a good sign. Welcome, Twiz. Okay, the first purpose identified. Right. Okay, hold on. Let me back up. First, the court is not convinced from the expert's explanation that the testing is within the scope of rebuttal. The first purpose identified, i.e. to ensure the defendant's self-reported symptoms are valid, might carry great importance if Dr. Orr's diagnoses were made largely based on the defendant's self-reporting, but they were not. Okay. Sounds like Judge Hippler is hinting at MMPI not being warranted here or admissible. Dr. Orr's neuropsychological examination included extensive interviews with defendant's family members, coworkers, former teachers, and psychologists, and an evaluation of the defendant's health and educational records. Moreover, Dr. Orr specifically observed that on symptom inventories, defendant chose not to comment. Right, we read this. Chose not to comment on any concerns about himself. Right, exactly. So that really does invalidate the state's expert saying, his concerns about the defendant portraying himself in a certain way if he didn't make any comments at all, right? So the defendant chose not to comment on any concerns about himself, and he showed very little insight into his behaviors and emotions. Then we have a footnote 11. Similarly, Dr. Bryan also observed during her forensic psychiatric examination of the defendant that he did not thrust forward. Oh boy. He did not thrust forward his symptoms in a manner suggesting malingering. Yeah, again, when you see that M-word malingering, you can be thinking of MMPI too. So what they're saying is, again, it's not necessary. And in fact, took great pains to minimize and deny psychiatric symptomatology. Well, again, understating could put you in the category from MMPI, but I don't think it's going to happen here. Different in civil trials, right? Different in civil trials. In other words, there was very little by way of self-reported symptoms. Consequently, the court struggles to understand why it is necessary to test the validity of self-reported symptoms through personality testing. I agree. The court's second and more significant concern is with the use of personality testing to rule out other diagnoses or personality characteristics that may account for the same symptoms. This has the potential to generate new mental health diagnoses, or other evidence outside the scope of the defendant's Fifth Amendment waiver. While the state asserts that its expert does not intend to explore new diagnoses or mental health conditions, there is a fine line, between ruling out other mental health conditions and, in quotes, exploring them. Yeah, well done, Judge Hippler. I like this. The danger of that line being crossed is too great and could lead to evidence that could be viewed as aggravating in nature, or I'm nodding my head, by the way, guys, or at least make it difficult to parse the aggravating evidence from the mitigating. Yep. And that was one of the concerns the defense raised a long time ago about mental health situations, about in some cases it's aggravating, some cases mitigating. Great point. Moreover, considering that the court is allowing the state an extension of time to examine the defendant and disclose its expert opinions, time is of the essence. Any new, right, great point as well here. You're on a time constraint here and you want to explore other avenues, give me a break. Any new potential diagnoses or evidence uncovered through personality testing may elicit the need for further testing and rebuttal by the defendant. Great point. As well as significant post-examination and motion practice. Weighing the marginal utility of personality testing in this case against the existing time constraints and the timing of the state's motion, considering its knowledge of the scope of the defense's agreement, the court will not allow it. Footnote 12. The court finds that even if the state otherwise should be entitled to administer personality testing, the state failed to preserve that right by not earlier seeking an order allowing it when they knew the defense would not agree. Again with that front and backhand spanking, guys, front and back of the hand spanking with this, because they did not make their motion in a timely manner. Oh boy. By not earlier seeking an order allowing it when they knew the defense would not agree to that part of the evaluation, and that personality testing, should the court approve it, likely could not be administered and scored in time for the state to meet its April disclosure deadline. This stands in contrast to the remainder of the state's requested evaluation, which was not objected to, leaving the state to believe an order would not be necessary as to it. Okay. However, to equalize the playing field, the court will not allow the defense experts to testify about whether the defendant meets or historically met the criteria for personality disorder or reference the state's failure to conduct personality testing on the defendant. That's fair. That would be opening the door. That's fair. In other words, the defendant cannot use personality disorder or the asserted non-existence thereof and the lack of testing for as a shield and a sword. I think that's fair. Moreover, the court will not prohibit its expert from commenting on the fact that personality testing may have aided in his evaluation, but that testing was not performed by the defense experts nor available to him. That's fair. In turn, the defendant may not assert or imply that, redacted, could have conducted personality testing. This approach strikes a balance. It does. It is a very balanced decision. I like this. Between ensuring the defendant's rights are preserved while at the same time allowing the state a means for effective rebuttal within the time constraints posed by the extension. Brilliant. Love this. Love it. This is great. Franks is making a quilt. Feel free to put some pictures in the Discord, Franks. We are all encouraging you on your quilt adventure. Happy quilting. And also welcome on in, Scott. Okay, the Sixth Amendment does not require counsel's presence at the exam. Finally, the state seeks to exclude defense counsel from its examination, asserting the defendant has no Sixth Amendment right to the presence of counsel at the examination. It further argues that exclusion of counsel is consistent with standard psychology practices and the American Bar Association standards on mental health, which advise that defense counsel should only be present if requested by the evaluator. Footnote 13. Okay, that's just saying what he just said. According to the new doctor, defense counsel's presence would interfere with the validity of the examination. He also points out defense counsel was not present when the defendant was examined by his own experts. Well, that right there. If they weren't present for that, okay, well, there you go. Yeah. If they weren't present for his own examination or examination by his own experts, rather, then I think that's fair. I don't see how you can, yeah. Okay, well, we didn't know that part. Defendant responds that he has a Sixth Amendment right to the presence of counsel during the examination because it is a critical stage in the proceeding. Yeah, but see, this all just falls hollow when you didn't have them there for your own experts. Anyway, particularly given that this is a capital case and death is different for Sixth Amendment purposes. He further notes that having counsel present, again, agree with all this, but you didn't have them there for your own examination. Scott's phone keeps crashing. There's been a number of iOS updates recently. I don't know if you have an iPhone, but that could be part of it. We don't need to read all this from the Constitution. He's going over what is a critical stage and what is not a critical stage. So reading the cases together, it says, suggests that regardless of whether an examination under the rules is critical stage or not, the Sixth Amendment still does not provide a right to the presence of counsel during the examination. So there you go. In fact, subsequent case law from the Idaho Court of Appeals supports this conclusion. Got another footnote, probably. Okay, and considering whether psychosexual examinations themselves were critical stages implicating the Sixth Amendment, the Court of Appeals observed that the majority of courts have held that while the decision to undergo pretrial psychiatric examinations, which are similar to psychosexual examinations, is a critical stage, the actual examination is not. So making a distinction between the stage that you're at in pretrial litigation versus the actual examination itself. Okay. Based on the distinctions drawn in Estrada and Estrell, EST cases, between the Sixth Amendment right to assistance versus the limited right to presence of counsel under the Fifth Amendment, the Court of Appeals in Hughes rejected the notion that the Sixth Amendment provides an absolute right of presence of counsel during a psychosexual examination, even if it were determined to be a critical stage. Indeed, most courts have concluded that a defendant has no constitutional right to be represented by counsel during the examination, either because the examination is not considered a critical stage. Again, he's just really thorough record here. Defendant, however, contains that Payne is not the controlling case law as it relied upon dicta, okay? He notes that Estrada declined to rule on whether the Sixth Amendment mandated, okay, interesting, the presence of counsel during a compelled mental examination, regardless of whether the statement was dicta. In Estrada, Hughes squarely held that the presence of counsel was not required at compelled mental examinations. Further, although Payne may have cited to dicta, its holding was not. At issue in Payne was whether counsel rendered ineffective assistance, a Sixth Amendment claim, by inter alia failing to be present during the examinations. The court held that the Sixth Amendment did not carry a right to the presence of counsel at the examination, thus Payne is controlling. Ironic that it's called Payne though, right? Defendant also contends that the plain language of the rule referring to an adversarial process triggered by a defendant placing a mental health condition at issue indicates that the examination is adversarial proceeding, unlike the psychosexual examinations where the expert is court appointed. However, even assuming the examination itself is an adversarial process and therefore a critical stage, Payne instructs that there is no right under the Sixth Amendment to the presence of counsel at the examination conducted by the state's expert. Okay, I don't think we need to read all this. He's just going through the different cases. I'm really just curious as to whether or not he's going to say they can have them there virtually, but it looks like probably not. Aha, there it is. That said, the court will allow, okay, there it is. That said, the court will allow counsel for both sides to watch the examination through a one-way video feed. I have to say, this might be a first on this live stream. I agree with every single one of Judge Hippler's decisions in everything that we've read today. I agree with all of it. I think this is fair. I think this is fair. Had the defense counsel been present when their own experts examined Bryan Kohberger, I would probably say that I'd probably have a different stance on it. But considering that they weren't, like for me, right? Considering that they weren't present for their own experts, I find it rings a bit hollow to me to be like, this is his right and da-da-da. It's a critical stage. Like, it's clearly not that critical, right? But I think, in other words, I think that Judge Hippler had every right to just even deny the virtual bit. I think he would have not, I think he would have been well within his bounds to deny the, having a video feed or whatever. And this is being very generous. Like, this is way more fair to the defense than I would have expected. Wow, I'm just very pleasantly surprised. So both sides, and again, it's like when you've got kids, right? And it's like split, it's like both sides can watch, right? Both count, both, that's fair. That's fair. Both sides to watch the examination through a one-way video feed or some similar method that prohibits them from being seen or heard during the examination. Under no circumstances will counsel be able to interrupt the examination. This is very fair. I am pleasantly surprised. So order, based on the foregoing, the state's motion for the examination of the defendant pursuant to Idaho code and an extension is granted in part and time part. The granted part, remember when at the very beginning of this document, when I was like, here's the three things, right? And the first thing was the extension of time. The second thing was the personality test. And the third thing was counsel being present. Remember what I said? I was like, my initial thing, I was like, on point number one, definitely granted. Like, that goes without saying, right? And then, so that he granted the extension in time, right? But he is denying the state the personality test. And then he's As far as being present for defense counsel, again, that's kind of a half and half. It's very fair. It's saying they can be present through a video feed and not in your fair. Very fair. Very fair. I'm very happy about that. Love to see that. So last but not least, we're going to take a look at the amended non-dissemination order to refresh all of our memories as to what is and is not allowed. I guess really what is not allowed. So, okay. We don't need to, we just want to see what it says here. Okay, it is hereby ordered the attorneys for any interested party in this case, including the prosecuting attorney, defense attorney, and any attorney representing a witness, victim, or victim's family, as well as the parties to the above entitled action, including but not limited to investigators, law enforcement personnel, and agents for the prosecuting attorney or defense attorney are prohibited from making extrajudicial statements, written or oral, concerning this case, except without additional comment, a quotation from or reference to the original public record of the case. This order specifically prohibits any statement which a reasonable person would expect to be disseminated by means of public communication that relates to the following. Wait, hold on, let me read that again. This order specifically prohibits any statement which a reasonable person would expect to be disseminated by means of public communication that relates to the following: evidence regarding the occurrences or transactions involved in this case, the character, credibility, reputation, or criminal record of a party, victim, or witness, or the identity of a witness, or the expected testimony of a party, victim, or witness, the performance or results of any examination or test, or refusal or failure of a person to submit to an examination of test, any opinion as to the merits of the case or claims of defense of a party. Any information a lawyer knows or reasonably should know is likely to be inadmissible as evidence at trial that would, if disclosed, create a substantial risk of prejudicing an impartial trial. Any information reasonably likely to interfere with a fair trial, in this case afforded under the U.S. and Idaho Constitution, such as the existence or contents of any confession, admission, or statement by the defendant, the possibility of a plea of guilt, or any opinion as to the defendant's guilt or innocence. So I think the most important part here is who it pertains to. The attorneys for any interested party in this case. Attorneys for anybody in this case, right? The parties themselves, including but not limited to investigators, law enforcement personnel, and agents for the prosecuting attorney or defense attorney, are prohibited from making extrajudicial statements. So as it pertains to the Dateline documentary, right? I guess what the question that many people have is like, where did they get this? You know, good. Well, they have it on good authority. They have a special source and da 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 da. Yeah, I don't know, because yeah, I mean, it shouldn't. They said it was somebody from didn't they say FBI cast at one point in there? I mean, as far as obtaining the video footage, that's not necessarily a statement from anybody, right? That's really more that's, I think, different, because this is really about, it's a statement, right? So a statement, so that's why I think it's really the bigger issue is when they had people like law enforcement officers, I guess, commenting to these Dateline people, you know, about the evidence. And when it was something that hadn't already come out in the public record. And I would imagine that, let's just say that something that they had commented on is in a public record, but it's one of the sealed documents. To my mind, like, I would say that still doesn't count as public record because it's not public yet, right? You know what I mean? Like, if it's in a sealed document, like, I don't think that's a way to get around it. To say it was something in a sealed, if it's sealed, it's sealed, right? For a reason. And everything that the stuff that was, you know, pertaining to like the cell phone records, and maybe, I guess the vehicle was really just the footage, right? I didn't watch the whole thing, as I said at the beginning of the live stream. I just skipped to the parts about the car and the phone. But, you know, the rest of the nonsense from people who went to school and whatever the fuck, random people, it doesn't matter. That's not, that it's like a bazillion layers of hearsay. It's completely inadmissible. None of that's going to come into trial. It's useless. But when they say that they have a reliable source, I mean, they referenced, it was like, sounded like a law enforcement officer, right? That they got information from about like the cell phone, maybe the car, but that would definitely be in violation of this non-dissemination order, in my opinion. But yeah, the footage of the car, I don't think would be as much of a problem because it's not a statement, right? But the statements from law enforcement are a problem as per this. They should not be. If they made statements about the evidence, right? That's not already a part of the public record. That clearly is a violation. And from what I recall is so the victims' families are not. I'd have to go back and listen to it, and I don't want to have to fucking do that. The way it was phrased from Keith Morrison made it sound like they got it directly from someone from the FBI. So, because Twiz is saying if it came from inside sources, that's what it sounded like to me. I did not. It sounded like, I mean, it could have just been the way it was phrased. I don't know. It sounded like he was referencing. I suppose I could go back and listen to it again, but then you have to go through all the ads. But I thought it sounded like it seemed like he was referencing somebody from the FBI. That's what it sounded like to me, and not like a parent of a victim. Could they not say it came from the FBI? Hold on, I don't understand what you mean. Could they not say it came from the FBI? I don't understand what that means, Twiz. Too many double negatives. Could they not say... Yeah, I'm not quite sure what you mean there with that question, Twiz. Defense attorney. And like, for example, let's just say that I mean, the other thing is this, right? If, let's just say, for the sake of the example, like hypothetically, let's just say that like somebody from law enforcement, for example, like, I don't know, maybe the FBI, for example, or any law enforcement agency, right, told a victim's family member information that has not come out yet as part of the public record. If that person yeah, that still wouldn't be okay. And here's why. Because a reasonable person would expect it to be disseminated, right? Like, for example, if you are an FBI agent or somebody from law enforcement and you tell Steve Gonzalez, right, X, Y, and Z, okay, and none of it has been made public record. It's a secret. Keep it secret, keep it safe type thing. You should expect Steve Gonzalez to tell people, because he's talking all the time to people, right? To the public, to media, right? That being said, I think that the best way to be safe about it is to not to tell anybody, right? Don't tell anyone, because it's like, oh, don't tell anyone. Okay, I pinky promise. And then they go tell people, right? I mean, it's just like being in middle or elementary school. And it's like, keeping a secret and then you don't keep a secret. You know what I mean? It's just like, you can't, the only way to ensure is to just not tell anybody. You know what I mean? I don't know what you mean, Twiz. Knew what he was searching for? What do you mean searching for? Like Googling or? Yeah, I mean, it's one of those things, right, where it's like, I don't know. I think it's one thing to keep the victims' families, and when you've got something like this, like in place, like a non-dissemination order, I think it's one thing to keep the victims' families apprised of like what's going on procedurally. I don't know why it's necessary to tell them evidence, right? Because I feel like that's just, I understand wanting that if you're a victim's family member, but there's just so many issues there. Not to mention, whatever you tell them may not be something that ends up coming in at trial, right? And then you could have a position where they are expecting this certain piece of evidence, and then it doesn't come in, and now they got their hopes up, and whatever the case may be, right? So I don't know, and that's the best case scenario. Worst case scenario is it gets disseminated, and then you have a bigger problem. So, but anyway, guys, it is time for us to switch on over to Karen Reed. So this should automatically redirect you guys. So that's it though for the latest docs here, but let me go ahead and get the outro ready, and I'll see you guys here on the other side in just a second.